Hey guys, Lawrence DeMonico here, president of Rare Breed Firearms and Rare Breed Triggers. I wanted to bring everyone up to speed on the current happenings, but while preparing for this update, extremely significant events have taken place, so the update was delayed to include the newest events. You are absolutely going to want to watch this video all the way through, as the most significant update is going to be at the end of the video. Now, if you don't already know, we sued the Attorney General, the DOJ, and the ATF in federal court in the Middle District of Florida last year. Now, the Reader's Digest version is that the ATF violated our due process rights guaranteed by the Constitution by closing the administrative record on our case before we were even made aware that our case existed. It is our belief that this was done intentionally to prevent us from being able to rebut their decision by submitting any evidence or testimony into the administrative record. Now, while the ATF reopened the administrative record numerous times to make their own additions to the record, they refused us the same opportunity. So the gist is this. We weren't given notice of the investigation until after the ATF had taken their quote-unquote final agency action. And then the ATF intentionally prevented us from contributing evidence and testimony into the record. And then, relying on administrative law, they argued that the administrative record was closed and the judge would need to make a ruling solely based on what they allowed to be in the administrative record. Now, while we had mountains of evidence and expert testimony to prove the FRT is not a machine gun, they did not want the judge to see any of it. Now, realizing that we were being railroaded, the judge allowed us the opportunity to amend our initial complaint in order to submit all of our evidence into the record, which of course we attempted to do. Now, the ATF still refused us that opportunity. Of course, we still submitted the evidence and testimony to the court, but the DOJ and ATF went so far as to file a motion in limine to prevent us from presenting our expert witnesses and evidence to the court. Now, the judge granted their motion in limine based on his assumption that the ATF had allowed us to add our evidence and testimony to the administrative record, but that we were just trying to add additional information. Now, our next hearing had a very limited scope in what we were able to argue because it was a hearing for a preliminary injunction. Now, in that hearing for preliminary injunction, we were only able to argue really two things. One was the likelihood of success on the merits of the case and irreparable harm. But we were not allowed to argue the actual merits of the case. Now, at the risk of upsetting the court, we used this opportunity to put our witnesses on the stand to speak on those issues, irreparable harm and the likelihood of success based on the merits. Now, while explaining to the court that we had a very high likelihood of success based on the merits of the case, our witnesses had to discuss the specific details or the merits of the case. Now, while the judge saw through our tactic and became agitated very quickly, he gave us a small bit of latitude. It wasn't until Brian Lukey, one of our expert witnesses, stated on the stand that if David Smith, the ATF examiner that had conducted the tests on the FRT15 and created this faulty report, had to get on the stand and testify to the accuracy of his report, he would be committing perjury. Now, at this point, the judge had had enough and ripped into our attorney for making arguments on the merits of the case. Now, the judge asked our attorney point blank if he knew why he had been given the opportunity to amend our initial complaint, and then Willie just told him that it was so that we would have the opportunity to add our evidence and testimony to the administrative record. Well, it wasn't until our attorney explained to the judge that the ATF still had not allowed us to do so, and that's why we had taken the approach to the hearing that we did. Well, that's when the judge learned that the ATF had still denied us the opportunity to add our evidence and testimony to the administrative record. Well, the judge was livid, and I kid you not, it was like a scene out of a movie. I saw fire in his eyes, and he looked directly at the U.S. attorney for the DOJ and asked if this was true. The DOJ attorney had informed the judge that it was true, that the administrative record was closed, and that they did not allow us to submit anything to it. Now, the judge knew we had been railroaded, and he was pissed. I mean, it was apparent. He was pissed. He asked us if we'd be willing to have our case remanded to the ATF and for them to start from scratch and reconsider our case. Of course, we responded with a yes, that'd be great. Well, he asked the DOJ attorney if the ATF would be willing to do the same. Well, the DOJ attorney didn't have an answer and asked for a recess to make some calls. After the recess, he came back and informed the judge that the ATF was unwilling to voluntarily take the case back. The judge then asked that we file a motion requesting a remand and formally request that the case be remanded back to the ATF. Well, while we were preparing that motion for remand, the court found a missed joint filing and booted the case. Now, let me explain this. A lot of people think that we just missed the date and the case was tossed, and that's really not the case. The joint filing required that our attorney and the DOJ attorney agree on some dates. It was more of a housekeeping document and submit it to the court. It was administrative. It had nothing to do with the case. So, anyway, in my opinion, I feel as if the judge knew we were right and that we were going to succeed, but he also didn't want anything to do with the case. So he looked for and found any possible reason to boot the case. So he just dismissed it, tossed it out, gone, a problem he no longer had to deal with. Now, that's that. Now, everyone wants to know what I've been up to and if I've just simply disappeared or crawled into a hole. Well, let me tell you, this couldn't be any further from the truth. I couldn't be any more active, and if I'm being honest, there just aren't enough hours in a day. You know, we are now involved in multiple patent infringement lawsuits, and that takes up a tremendous amount of our time. And then, of course, we're still dealing with the DOJ and the ATF. But we have been crossing our T's, dotting our I's, and building a very strong case. Now, I'm going to hit the high points on numerous items as I continue. But we've been working very hard on our new case, and we're preparing to file that lawsuit against the ATF on Monday morning in our current place of business, which is North Dakota. Now, we're going to make many of the same arguments that we did in the last case, but we're also suing for the intentional misclassification of our product. This is a tortious interference claim and isn't subject to the administrative law rules that the ATF tried to play last time. Now, we still feel very strongly that the judge can look outside the administrative record since the ATF did not give us an opportunity to be heard or add any information into the record and thus denied us due process. Well, the lawsuit will be public record, and I'll post up a copy of it so you all can read the details for yourself. But we will also be posting all of our opinion letters, ATF examination rebuttal letters, and a couple of videos to our website, and may get them posted to a couple other websites as well. We want to make sure that all this information is available for our customers in case the ATF continues with this reckless disregard for the rule of law and escalates this even further. Now, the ATF recently put out a notice to FFL dealers saying that some FRTs are machine guns. Some. First, they state that they have determined some forced reset triggers to be machine guns, without identifying which ones are and which ones are not. Now, the intent is clearly to create a chilling effect on those that choose to exercise their rights. Now, second, they correctly recite the statutory definition of machine gun. The term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. Now, single function of the trigger is the portion to note here, because then they immediately apply their own different definition by replacing single function of the trigger with single continuous pull of the trigger. They then go on to state that some FRTs function by a single continuous pull of the trigger, and if one does, then they have determined it to be a machine gun. Now, one of the many problems here is that a function of the trigger is something the trigger does. A pull of the trigger is something done by an external source, i.e. the shooter's finger. These two things are not the same. In fact, they are very far from the same thing. So to simplify this down to the most basic level, here's what the ATF is attempting to do. They state that a machine gun is defined by federal law as X, and that if your FRT does Y, then it's a machine gun. This makes zero sense, as X and Y are not the same thing. X does not equal Y. Third, let's talk about authority. Does an executive agency have the authority to expand legislation? Does an executive agency have the authority to redefine a federal law? The answer is very simple. It's no. No, they do not have the authority to bypass Congress, expand a criminal statute by claiming X equals Y. It's just not possible. Fourth, let's discuss reset. Reset. One does not have to release a trigger for it to reset. Further, one does not have to pull and release the trigger, as the ATF letter states is required by law. One's finger must never come off the trigger. One's finger must never release the trigger. This is a complete falsehood, and everyone knows it. Rather, one must only pull the trigger hard enough for it to function, then adjust the pressure just enough to allow the trigger to reset. I mean, we could talk about single-stage triggers, two-stage triggers here. And in doing so, it is completely normal and perfectly legal to have maintained some level of continuous rearward pressure before pulling it again to cause a subsequent function of the trigger. Now, this language they are trying to insert in a criminal statute is fundamentally new and is attempting to expand the law, which I just explained the ATF does not have the authority to do. Now, the main takeaway that we would like people to have is that no administrative agency has the authority to create laws. The ATF has no authority to change a law. If it wants a law changed, it must go to Congress and ask Congress to do so. Congress has been asked to change the definition of a machine gun to include bump stocks and other so-called fire rate enhancing devices. Congress answered no. In fact, at least 4 bills have been introduced in Congress that propose bump stock bans, though none of them went far enough for a vote in either house. Okay. Whew. Now to bring everyone up to speed on most recent events. We have several vendors that help us with manufacturing. One of those vendors was sent a cease and desist letter by the ATF on January 12th of this year demanding they stop manufacturing and turn over all FRT15s in their possession. The letter also stated that they would be notified why the products were illegal at a later time. Now here's a cease and desist letter, and the ATF is demanding that you stop manufacturing and turn over all FRT15s. But we'll tell you at some point later, I don't know when, but some point later, why they're illegal. Now, of course, through their counsel, this vendor replied to the ATF explaining that the FRT15 doesn't function as the ATF has alleged, and they would not be able to comply until such time that the ATF provided them with a detailed explanation as to how the FRT15 is illegal. Now, it's no surprise, we're in America. And in America, we are supposed to be free citizens, and we have no obligation to follow an unlawful or unconstitutional order. Now, this vendor feels the same way and simply requested an explanation before they would comply. When the vendor's attorney sent the response, it was accompanied with high-speed slow-motion videos demonstrating exactly how the FRT15 functions. Numerous expert opinion letters, rebuttal letters, and formally asked the ATF if those items had been considered. Now, of course, the ATF didn't bother responding to them with an explanation of how the FRT15 could be illegal, since it's not. Very plainly, it is not. In fact, they didn't respond at all. Now, instead, this morning they rolled up to this vendor's business with guns drawn and raided their facility. At this time, I have no idea what was seized, but with that said, I do know that they keep very little of our products on hand, so I don't expect they got much. I also still don't know the full scope of what all they took. I suspect they didn't just stick to taking FRT15s or their components, as it appears that the ATF's goal here is to really make an example of anybody that dares not bend the knee. My guess is that they probably hope if they can make an example of enough people, others won't stand up to them. Well, that's not me. While on the stand in our last hearing before the case in Florida was dismissed, our expert witness, Brian Lukey, testified that one of the most significant problems with the faulty technical evaluation and report done by ATF examiner David Smith and approved by ATF Tech Branch Chief Earl Griffith is that at some point law enforcement agencies and judges across the country would be using it as grounds to obtain warrants. So again, even though the ATF knows that their exam and report are absolute bullshit, they still went to a judge and used it to obtain a warrant in an attempt to destroy another American business. Now, of course, the first question many of you might have is, oh my goodness, does this vendor have any customer data? And the answer is no, they do not. But while we're on the topic, let's talk about customer data. Although I feel I've answered this question 100 times, I'll address it again now. One of the most common questions that I get from our customers is if we would turn over our customer records. Well, we've answered this multiple times, but I'll say it again right now for the record. If the ATF asks us for our records, the answer is a very simple no. You can't have them. Now, if the ATF has a court order for our records, we would, of course, comply. But we cannot turn over what we don't have. While it's plainly written in our privacy policy on our website, I will go ahead and explain it here as well. We have a digital shredding policy. So once we no longer need a customer's personal info for legitimate business purposes, it's automatically scrubbed from our system. We don't take any steps to do it. It happens automatically. So with that said, we cannot turn over what we don't have. Okay. Now, if you have an order pending that hasn't shipped, we still intend on shipping your order, so please don't panic. Now, if something changes and we're unable to fulfill your order, we will let you know and we'll issue you a refund. So don't freak out. Don't panic. Don't blow us up asking about it. Don't send a bazillion emails to customer service. We will get you taken care of. So the bottom line is that the ATF has become a rogue agency. They are operating outside the rule of law and they need to be reined in. And so here it is. Here's the call to action. We need you all to write your senators and congressmen and all the YouTubers that support the Second Amendment or just freedom in general. Now's the time to make some noise. We can't allow a small group of unelected bureaucrats to make new laws. It's not legal. It's not constitutional, and we can't allow it. We need to stop them now, or they will continue down this path until we are no longer a free country. I mean, if they can change the definition of a machine gun to include a trigger that is a perfectly legal semi-automatic trigger, what is to prevent them from just changing the definition of machine gun to include any AR-15? They can just allege and claim that it is a bunch of parts that can be readily assembled to be a machine gun. Enough is enough. We've got to put an end to this. Now, this is all I have for you now. I'll put out another video in a couple of days after I have some time to wrap my arms around the situation. Now, before I close, guys, I'd like to thank you all for your support. I mean, to be honest, even the assholes that constantly talk trash about rare breed triggers and me personally, I mean, really, you're just feeding the fire. Because we're not going to stand down. We're not going to bend the knee. We've done nothing wrong. The FRT15 is 100% completely within the law. It is a perfectly legal semi-automatic trigger. All right, guys. I'll stop this video before it gets dark and there's nothing left to see. Have a good night. Have a good weekend. Expect more from me in a couple of days. And once again, guys, thank you all for your support.